complaint that alleges that on or about July 20th, 2025, location in Pittsfield Township, specifically that being Washington Avenue.
All right, folks, the date's on the record, the location's on the record. Now the real question is, will the defendant's memory suddenly improve when the stakes become crystal clear?
That you did at that time had possession of drug paraphernalia. You understand that, sir?
No, I don't, sir.
Pardon?
I have no idea what this is about with paraphernalia.
Okay, so you have a complaint that alleges that on the date I just said, at that location, they're alleging that you were in possession of drug paraphernalia. I'm not asking, not saying whether or not you did it. You understand what you were charged with?
Yeah,
Do you understand what you were charged with?
I do today, yeah, actually.
Okay.
Today I was being charged.
And
90 days in jail and a $500 fine. Plus, the court can order treatment. This isn't just a slap on the wrist. It's the court's way of saying, get clean, or get comfortable in county.
that is a misdemeanor, punishable by up to 90 days in jail, $500 fine plus court costs, and the court could order any substance abuse treatment. You understand that, sir?
Yes, yeah, sure.
You understand that?
Yeah,
Do you wish to be represented by an attorney?
absolutely.
At this point, this is a public defender case. And then somehow or another, they'll make the magical switch somehow or another.
For the time being, Assistant Public Defender Natalie Davis, and on behalf of Ms. Party, we would waive any further reading. My client stands mute and ask that a not guilty plea be entered, and we would ask for an adjourned pre-trial date.
Then have a waive formal reading standing mute. The court will enter a not guilty plea. Pre-trial in this matter will be adjourned. Did they say how fast they can make things happen? They can make it happen, brother.
They didn't say, Your Honor. I don't know.
All right. Why don't September 17th, will that work?
Works for me, Your Honor.
All right. I'll adjourn it out to September 17th, 2025. And as to your other matter, you want me to adjourn it to that same day?
Yes, please, Your Honor.
All right, so we'll adjourn this one to September 17th. Let me set bond conditions on me. Pardon? I don't know that that's a violation, is it? So we got a problem. They've listed it as a progress report, but on August 1st.
And there it is. The test results don't lie. No prescription. That's like walking into court with a neon sign over your head, flashing probable cause.
Did a 10 panel, or was supposed to do a 10 panel. He missed his test, stated he didn't have money to do it at the time. On August 4th, he did a 10 panel. Problem is, he came up positive for amphetamines. And he denied having any current prescriptions that would have shown that.
Can I speak with him?
Pardon?
I called them and I asked them what I should do if I should come in and test them first. And they told me, don't worry about it and call back the next day. And I called back and then I think the days are messed up. Like the moment I went and saw them, I went and tested.
What do you mean the days are messed up?
Because you said it's from the 1st and the 4th. And it was only a day after that I had spoken with them.
I'm indicating what this says. I wasn't there. Okay?
Yeah.
So I'm telling what it says. I am not so much concerned about the dates. I'm more concerned about why you have amphetamines in your system.
I've been taking Adderall since I was 7 years old.
Did you tell them that you have a prescription? Do you have a prescription for
I
it?
lost my prescription, sir.
Pardon?
I lost my prescription. I had to change doctors. Me and him got into it. I even had the doctor's note from him saying that you can no longer be my, prescriber. Complicated story. Me and him got into it.
So you don't have a prescription?
No, I no longer have a primary care physician.
Translation: one more slip up, and you're trading that public defender for an orange jumpsuit. The judge isn't just making threats here, he's laying down the legal landmines.
All right. Here's what I'm going to do. Sometime between now and the 17th, he needs to get back on and have his testing as he's supposed to have it. I'm not going to sit up here and argue with him tonight. Because I don't know, he knows what he's eating. I don't want to see those amphetamines unless he has a prescription in the system. Otherwise, I'm just going to make it real clear to you. I'll revoke your bond and you'll sit in jail until we get this thing done. Okay. Am I clear on that?
Yeah, I was just saying he's no longer prescribed to me.
Am I clear?
Yes, sir.
I don't really need any more language from you.
Yes, Your Honor.
This bond in this case at this time will be set as $10,000 personal recognizance of lower standard conditions, including no assaultive behavior, no alcohol, recreational marijuana, or illegal drug use, no possession of any weapons. I will sign a new community corrections order. I want him for testing. I want him tested once a week. All right. Thank you.
Thank you, Your Honor.
Assistant Public Defender Alexis serves on behalf of Mr. Thurman, who's approaching.
Olin Thurman.
Okay. Record should reflect prior to the system going down that we were having a bench conference. We concluded that bench conference. Fundamentally, the defendant was released to a particular address on a tether. That address is no longer available to him. He, in a nutshell, has a place which he can be released to. However, his release to that place would be in violation of his current bond conditions.
Yes, Your Honor.
Even if there's somebody there. Even if there's somebody there.
Your Honor, and just to further, he doesn't have any other location to go. It is my understanding that there'll always be some other adult present at that location. Even when the mother's children does go to work, her parents come to watch the children while she's at work. So if the court's concerned, we would ask for that bond condition to be modified to say no children except his own children. Like Your Honor is aware, they are his children, and the mother is present in court and is willing to.
Right. I understand, but with reference to the primary case, his release, his contact with his own children of that other relationship is only supervised. Right? So
This is where it gets tricky. Housing restrictions on bond can feel impossible, but in cases involving minors, the court plays it extra safe. Better no bed than a bond violation.
And I get why you may be asking, but what you're in effect asking the court to do is then to release him in the presence of kids unsupervised.
Well, Your Honor, it's my understanding that there will always be someone else at the home while the children are present.
Yes, and I get that. I'm saying it's not a structured supervision under sort of some type of monitoring. I get what you're saying. And I'm uncomfortable doing that. Young man, you don't have any other place that you could stay?
No, sir.
Okay, because here's the problem. I'm gonna do this in a way to try to be fair, because he's come here, he said what his circumstance is. He's been released, can't go back to the place that he was. Has tried to find, in good faith, I think, alternative living arrangements. And so I'm not faulting him for that. I just think that releasing him to that would be in violation of his current bond conditions. when I look at the bond conditions, the charges, I think that those bond conditions are appropriate. And so I'm not going to even modify or tweak those bond conditions in this case. I don't know enough to do that, first of all. But I also want to be fair to the defendant. So what I'm going to do, counsel, is I'm going to pass this to my 3 o'clock block.
Okay.
Give you an opportunity to try to find some other alternative in doing that. I think that's probably the best I'm going to do. I'm in effect, really what I'm doing is I'm resisting putting him back in. I'm going to give you a chance to kind of brainstorm, figure out something else before I'd have to come to that point. Okay?
Understood, Your Honor.
Okay. So we'll pass this to the 3 o'clock block. My last.
Assistant Public Defender Alexis Jefferson on behalf of Mr. Thurman.
All right. And this is a recall. Were we able to make any progress?
Your Honor, I believe I will be renewing my request to allow him to be tethered to his mother's children's house. So it is my understanding that allowing him to stay there would not be a violation of his current bond conditions because he is allowed to have supervised visitation with those children. And at this time, he will always be supervised.
Well, no. Because as I understand the bond conditions, he's not to have any contact with any children. Was the exception to that were the children that were the alleged victims in this case.
Your Honor, if I may clarify, I don't know if this was entirely clear earlier. The alleged minors involved in this case are not actually Mr. Thurman's children. Those are the
Right, correct.
children. He does not share
You're
those.
right. I misspoke. But he wasn't to have any contact with any children. The two other children, there was an exception for supervised visitation.
Correct. And Your Honor, my argument is that that is what he'd be partaking in by residing in that home. There would always be another individual present in that household. The children's mother takes the children to her parents' house during the day while she's at work. She picks up those kids, brings them home. Mr. Thurman would be obviously home by himself without the kids there. They would be at the parents' house, the grandparents' house, and then the kids would return with the mother. So the mother would always be present during those interactions.
On the record, we would be objecting to that, given the fact that we can't make sure that that happens all the time. And I would have great concerns of him being around children and living in a residence with the children, given the facts of the case. So we would be objecting.
Whoa, hidden cameras, minors recorded, and the videos sent to others. That's the kind of detail that turns a bond hearing from routine to jaw-dropping in seconds.
For that reason.
And Your Honor, respectfully, even with the condition that he was allowed to have supervised visitation, there'd be no way to guarantee that that was taking place in the first place either. Your Honor, all this is being based off of right now is a 4-page police report. We did just receive some